I'm Attorney Zach Townsend with Pro Legal Care. Orders of protection are special forms of remedies to help people that have been abused or harassed by an abusive person. An order of protection can be scary because it's complicated. There can be many different kinds of orders of protection. Remedies regarding your home, your children, property, or money, all of those are available in orders of protection. The main purpose of an order of protection is to prevent an abuse victim from continuing to be abused. And if you're watching this video, chances are you have experienced something traumatic, you have experienced aggression, or maybe you have experienced abuse. You may be a candidate for an order of protection. An emergency order of protection does not require you to provide notice to the abuser before you obtain or seek to obtain the emergency order of protection. That is to keep you safe. The emergency order of protection will last normally 14 to 21 days. It's only a short-term period because the abusive person does not have the right to notice in advance or to be heard or to be present for the emergency hearing. For that reason, the relief is short-term in nature. Do you need a police report to obtain an order of protection? The answer is no. Do you need to have been caused physical abuse to obtain an order of protection? The answer is no. The majority of abuse is non-physical abuse. Harassment is considered to be abuse under the Illinois Domestic Violence Act. Intimidation is considered to be abuse under the Domestic Violence Act. Any intentional distress that somebody causes you solely for that purpose can be considered abuse and can be a basis for an order of protection. If your ex or your partner won't leave you alone, that might be a basis for an order of protection. If your partner is texting you or calling you and you say, please do not contact me, please stop texting me, and they continue to do so, that might be grounds for an order of protection. If your ex is threatening you, that would be grounds for an order of protection. If your ex is threatening to disappear with your kids, that can be grounds for an order of protection. There are many different reasons why you may qualify for an order of protection. And one of the important remedies is that you have a safe home, that you have a safe place to live. And that's why if there's abuse that has occurred, the judge may award you exclusive use and possession of the house. That way you can have physical safety and emotional safety. An order of protection on an emergency basis can be obtained without notice to the other side and without the other side being present. And that is called ex parte. That is a lawyer word to describe a case that only has one party present. Without the other side present, they have no opportunity to make their case or to rebut your allegations. And the reason is for your own safety. Because if you give an abusive person notice that you are going to seek an order of protection, that might lead to further abuse before you even have the opportunity to get the order to prevent it. How do you go about petitioning the court for an order of protection? Paperwork is required to be completed. Paperwork that specifies in detail the abuse that occurred and the effect that it had on you and why you need an emergency order of protection. That gets filed with the court, and usually the court will obtain a judge to hear your request right away. That means that you are able to walk in and see the judge on the same day. When you fill out the paperwork, you should do so with the help of an attorney because it can be very complicated. You have to meet very specific technical requirements, and you have to include allegations that constitute and amount to abuse. And without that, your order of protection would be denied. When you complete the petition for order of protection, you are making a request for an emergency order of protection as well as what's called a plenary order of protection. The plenary order of protection can last up to 2 years and is not done on an ex parte basis, but done with both parties having the opportunity to be heard and to make their case. That's why it can last a lot longer than an emergency order of protection. When you submit a request for an order of protection, you are generally asking for both That means that you may have your emergency order of protection denied, but you still can obtain a plenary order of protection. You also may have your emergency order of protection granted and then have your plenary order of protection denied. They do not necessarily work in concert, but they are interrelated. Once a judge is available, you will be brought before the judge, and the judge will ask you, why do you believe that you need an order of protection? And that's your opportunity to explain the type of abuse that has occurred and the type of abuse that the respondent has caused you and how it has affected you. It's important to know that when you petition for an order of protection, whether it's on an emergency basis or not, your responding party, the other side, usually your ex, is going to be served with the papers, is going to know exactly what it says. That's part of what is required if you are going to seek to have an order of protection. Can you obtain an order of protection on behalf of a child? The answer is yes. A child can be a petitioner or named as a protected party on an order of protection. That means that the respondent would not be allowed to have contact with that child except as specifically provided in the order of protection. Children are vulnerable and are at a greater risk to harm than adults who are better able to protect themselves. So some judges are a lot more willing to go out on a limb to protect the children. With an order of protection, you can have the child's school as a protected address where the respondent is not allowed to go. The respondent can be prohibited from accessing the medical records or school records of the child. There also can be requirements that the child be returned, or that the child not be concealed, or that the child not be abused. Those are remedies that can be specifically ordered in an order of protection. There's also the opportunity sometimes for child support, even through an order of protection. There are many different ways that an order of protection can be used to keep your children safe. Orders of protection will supersede a visitation schedule. Orders of protection will sometimes, though, include visitation. An order of protection can have a schedule spelled out right inside the order of protection. An order of protection can have restrictions such as requiring a supervisor to be present for that visitation. It all depends on the specific facts of the case. If abuse to a child is alleged in an order of protection, a guardian ad litem may well be appointed. A guardian ad litem is an attorney that represents the interests of the child, an attorney appointed by the court to do just that. Represent and advocate for the interests of the child. That person would do an inquiry or an investigation and report back to the court with recommendations about the child and the arrangements for the child and the child's parents. That can happen in an order of protection. If you believe that you need an order of protection, chances are you're under a lot of stress. It's probably been affecting you. Maybe you can't sleep very well. It's the type of thing that maybe you can't even function. This is help that you may not have been able to plan for, and you need assistance when you're in a situation like this. Ideally, you need it from an attorney, private counsel such as myself, experienced in this area of law. However, there are options for people who cannot afford private counsel. The Stephenson County Courthouse have really good assistants, advocates, non-attorney advocates that can help you seek an order of protection if it's appropriate. The Winnebago County Courthouse, also a really great victims advocate program that can help you if you need, or if you think that you need, an order of protection and you want somebody to talk to about it. The Family Peace Center in Rockford also can help you. If you are in a position where you need protection from domestic violence, you need an order of protection, but you're not able to afford it, you can also seek out help from Prairie State Legal Services or the Northern Illinois University Legal Clinic. Seek out your options. There's help out there. If you've experienced abuse and you obtain an order of protection that's granted against the person who is abusing you, there is an opportunity to seek attorney's fees from the respondent. The Illinois Domestic Violence Act allows for a person to seek attorney's fees or other compensation for losses. If there were expenses incurred as a result of the abuse, and that includes attorney's fees, the judge has the ability to grant a money judgment and require the respondent to pay money for your losses. Even though attorney's fees are listed as an expense that's recoverable pursuant to the Domestic Violence Act, generally, judges are discouraged from granting attorney's fees. The American rule is that each party is required to pay for their own attorney's fees. So without some extraordinary exception, each party is going to be required to pay for their own attorney's fees. And unfortunately, it ends up being usually, if it's granted, a portion of those attorney's fees, and only after the fact. So it can be very challenging to obtain the attorney's fees that are listed as provided in the Illinois Domestic Violence Act, especially because once there is a judgment, then that judgment needs to be collected on. That can be very challenging and expensive in and of itself. While it's permitted under the Domestic Violence Act, it generally does not occur except for in the most extreme situations. How is an order of protection enforced? It's a very good question, and the answer is complicated. Pursuant to law, if a person violates an order of protection, then they may be arrested and charged with a crime. A violation of an order of protection is a crime. But like all crimes, sometimes they're not charged. Sometimes the police have perhaps what they believe to be more egregious issues to deal with. The same is true for judges. Violations of orders of protection are often clouded. They are not clearly seen. They're distorted, often by the respondent, who attempts to weasel their way out of accountability. The first step is to have the respondent served with the order of protection. If the respondent is not served with the order of protection, then that person could say that they didn't have notice or reason to know that they were not allowed to have the contact or whatever it was that they did that actually violated the order of protection. The respondent is served by a deputy sheriff, and the deputy sheriff will hand deliver the documents to the respondent. And that's what's known as service. It's also called service of process. Until the respondent is served, your order of protection may not be enforceable. So it's very important to make sure that the respondent is served. And this is of particular importance when the respondent does not reside in the county where the order of protection was granted, because the paperwork for the order of protection that needs to get served has to go to the county in which the respondent resides, so that way there can be an attempt of service on the respondent. If you know where the respondent is, but not where the respondent resides, they can also be found that way as well, such as where they were. But it's important to follow up with that. You can call the sheriff's department and ask, "Hi, I have an order of protection. I want to know if the respondent was served yet," and they will give you information. You will want to know when the respondent was served, because that's when your order of protection becomes enforceable. There are many obstacles that you might run into when trying to enforce an order of protection based on logistics, resources, even convenience. It's important to do everything that you can to facilitate the process. That's why it's important for you to follow up to confirm that service was made. And that's why it's important for you to know when service was made, and if possible, to have what's called the affidavit of service, which is the proof of the service. This is the same reason why you should always carry with you your order of protection paperwork. You should have a copy in your glove box. You should have a copy in your purse. You should have a copy at home. You should have a copy with your loved ones or family. You should have these very accessible, because the moment that there is a violation and you contact the police might say, "I need a copy of that." And if you don't have it, they might move on. You want to do everything you can to take away their objections, to take away any reasoning that they have that would make it challenging for them to do their job. Help them do their job, and then that's going to help you out. That's why you want to have the order of protection handy, so you can provide it to an officer or anybody that needs to see it. And that includes a school or a daycare or a medical provider. When an order of protection is granted, the information is supposed to go into what's called the Law Enforcement Agency Database System. So the police officers are supposed to have the information available to them. However, technology doesn't always work the way we want it to. It's also an issue of time and resources and how seriously people are going to take your situation. And unfortunately, it's not uncommon for a police officer to not take your situation as seriously as perhaps they should. They might say, "I've got burglaries and real crimes to deal with." That's not okay. That's not right. But sometimes that's the reality of the situation. So you want to do everything you can to make sure that you provide the officers all the information that you can, and that you have service made, that you have copies of the order of protection, that you know the details, such as the date the order of protection was granted, the date that the respondent was served, and that's going to be a way that you can protect yourself to make sure that your order of protection is properly enforced. If you are researching orders of protection, you probably need help more than you even realize. But you need to speak to an attorney to make sure that you do it the right way. And you need to make sure that you don't cause yourself to miss your opportunity. Give me a call and we will discuss your options. Reach out to us today to schedule your consultation. We'll help you find a new path forward.